Hello and welcome to The Trust Factor, the Q&A legal information show dedicated to helping real people find simple solutions to their sometimes complex legal questions. Our next question is directed towards Phil, our probate panel member, and it comes to us from Jerry in Anaheim Hills via email. Jerry wants to know, my brother is the executor of the estate and he has not done anything for 10 months. Should I be concerned?
Yes, you should be concerned. Your brother has a duty to give you a copy of the trust. He's required to do it within 60 days, but really there's no reason to even wait 60 days. A trustee should give you a copy of the trust immediately or upon your request. They're required to also keep you informed of their activities, at least reasonably informed. And if they don't give you a copy of the trust within, say, 60 days, then you should be concerned. There's no reason not to. You ask yourself, well, why wouldn't he give me a copy of the trust? What's he hiding? Is he just angry with me? Is there any reason for him to be angry with you? And even if he is, that's no reason for him to shirk his duty to follow the terms of the trust and to give you a copy of the trust. So, yes, you should be concerned. 10 months is too long. You need to get to an attorney right away.
For those of you who are watching today's broadcast who may have your own questions on these topics and more, visit us online at legaladvicepanel.com. In creating our show, we've come across many people who have what we call legal nightmares. From courtrooms across the state and through our Legal Advice Panel website, we collect horror stories, we broadcast them in hopes that everyone can learn something from them. Let's take a look at our first legal nightmare.
We had a trust, my dad and I had a trust set up that was set up for his fifth wife with her blessing and with her knowledge, and she was involved with it all the way through. That was set up so that she could live in the apartment building for the rest of her life and enjoy the income off the apartments on the condition that the apartments were never sold, that they would stay in the Wood family trust. Then when my dad passed away, the day after we had his memorial, she put for sale signs up on the property, and basically she just wanted the money out of the apartments. Basically one apartment building was lost and should never have been lost. I would say that was probably about $1 million that was lost there. In legal counsel, I would say on both sides, over 3 years, it was probably $250,000, $300,000. So huge amounts of money, and of which, I mean, we're not those type of people that can pay for that much. I had to take a loan out on the second apartment building to be able to pay the attorney fees.
Do you have any legal advice on this legal nightmare, Phil?
These types of scenarios happen all the time. It can happen when someone creates a new trust, or it can happen when someone creates an amendment to a trust. And if you violate any of those duties, the beneficiaries of the trust have the right to go to court and ask the judge to suspend your powers and to remove you as trustee. Beneficiaries have a lot of rights, and the courts are open to them. They have remedies, and if you don't act, rest assured that you're going to be sitting in front of a judge someday trying to defend yourself, and it could cost you a lot of money. Those types of scenarios present themselves all the time. It's something you need to be aware of. You absolutely need competent counsel if you're faced with that type of a problem, and don't wait. You have a limited amount of time to contest those trusts. Get to an attorney right away and have them review it with you.
I'm sure that sound advice will help many of our viewers, Phil. And remember, for those watching the show, if you have a legal nightmare that you'd like to share with our Trust Factor audience and or get your legal questions answered, log on to legaladvicepanel.com and click on the Legal Nightmare tab.